I did get my first DNA case in 1995, and it went like this. Everybody in the office had a murder, except for me, because I'd only been a public defender for 11 months, and then somebody else died, and somebody else got charged, and boom. Welcome to the public defender's office. So I tried it with my boss, who said to me, I'm not learning this crap, which of course meant I had to learn it. I didn't learn it all in my first case. I didn't learn it well for a very long time. I didn't go to my first DNA or forensic training until 2000. So there was 5 years of me trying to figure it out on my own. So when I see you guys coming to something like this, I'm so excited for you, and I'm happy to tell you what I know. And our other faculty, we take time to come here because we don't want you to have that same experience. So if you have questions while I'm talking, I'm fine with that. Okay, questions that start out, I have a case, generally aren't questions that are good for this sort of a talk, but if you've got a shorter, more general question, how do you func, that's interesting for arson, but I've got a DNA case, how do you extrapolate, that sort of thing, knock yourselves out, all right? Also, if I move away from the microphone, somebody remind me, because I'm not supposed to do that, but I'm a pacer. So, real or really sucky? That's the question, all right? All right, so I clipped that this morning. I found that. I thought it was funny. Of course, we all know what happened to Jesus when he questioned authority. But that's our starting point, okay? When we get a scientific case and the person says to you the absence of an accelerant is proof that an accelerant was used, you say, that doesn't make sense, all right? If someone says to you, well, we'll get to some other examples in a minute. But regardless of what happened, you get the report that says your guy's DNA is in the underwear. You need to look at it, okay? Question everything. So this, we've already talked about what you asked for in discovery in an arson case. I want to talk about my first two pictures for a minute because you want pictures. You do not want photocopies, okay? You can't tell what's going on in this picture. Your expert can't tell what's going on in this picture. You want that picture, all right? And they can. And these days, it doesn't cost nearly as much as it did back when I first started doing murder cases, right? Because you'd have 1,000 pictures, and you'd have to pay for them to get, processed. And now it's just all on. They can just download it onto your computer. So get those. If there's a video, if you've got a murder case, the crime. Okay, so you got a murder case, there's forensic evidence. Why are you bothering to look at the video, right, that the crime scene team made? Well, because I want to know what they didn't collect. And there's never going to be a report that says we didn't bother to collect the beer can with the lipstick in a shade that didn't belong to the wife that was sitting on the counter, right? So even though technically, when you're asking for a video of a crime scene, you may not be thinking forensic, but that's why we want it, all right? When you see your case on the news, understand there's more footage than what you saw, okay? When you see the chief of police being interviewed on the news, if you're that lucky, all right? I was on the news a couple nights ago for about 30 seconds. I talked to him for a half an hour. And by the way, I sounded really smart, but I will tell you, both of the things that I said were completely taken out of context, okay? So you want to get that video from Channel 4 or Channel 11 or whatever it is if you have that opportunity. The lawyers in the O.J. Simpson case talked about how they had that opportunity because, that was on the news the whole time, right? So what happens? They watch these over and over, these videos and these interviews and the pictures. Bob Glazer told me he took all of the OJ photos and put them on his computer and just had them rotating all the time. Because when you're having them rotate all the time, right, you start to see different things once you get used to the gruesome, ugly thing that's up front. And one of the things they found in one of the news videos was, what? They're interviewing like the chief of police or something, and it's a close-up interview, right? So you had to be paying attention, you had to be looking outside that box, if you will. You can see one of the medical examiners dragging the body through the crime scene, okay? Contaminating the crime scene, right? Now, in arson cases, essentially we always have a compromised crime scene because there's always people who went in and maybe damaged or destroyed some of the evidence. what else do we want? We want the lab, in addition to the lab report, we want the actual, and I know you've heard this before, underlying file. Can't be stressed enough. I want the underlying file. This is what kerosene looks like structurally if it gets sent to a laboratory. You get your ladder for kerosene, you get your test result, and you compare the two with your own eyes. All right? If you're not comfortable with it, bring it down to the chemistry professor at the local college to compare the two with your own eyes to see, is this the chemical compound that is found in your case. All right? Okay. This is important language, and here's how this is a lesson that I learned the hard way. Happily, my client didn't suffer. It was a DNA case, and they were doing batches, right? So they tested 4 DNA cases at the same time. And my client's DNA shows up in the rape case that I've got him on, and a rape case, 17 counties away, which happened to be the next one in the queue. And the scientist said, well, I thought that was unusual, right? So I double-checked. It turned out he had taken my client's DNA and somehow contaminated the next thing in line, okay? Now, I did not get any information about this contamination until about a week before trial because the lab analyst was calling, begging the prosecutor to resolve the case, right? Because the QAR, okay, the quality assurance review, the report about the contamination, went into the file that was contaminated, not my file. So now I ask for any other reports that are generated in conjunction with this file. All right? That may, depending on your laboratory, also give you the benefit of a report that you didn't know existed. Maybe the stuff got sent to do shoe prints and you didn't know about that report and nobody thought to send it to you. All right. Copies of notes taken as seen. Now this is arson specific where it says as best practice pursuant to NFPA 921. Okay, because it says that in 921 that the best practice is to take notes at the scene. All right? If you're doing a DNA case, you want to look up the DNA Advisory Board standards, which are online. The FBI issued them to look at what they say the best practices are in the DNA cases. There are other areas that have best practices and some areas, quite frankly, that don't have best practices. So look around, see what you got going, what's available. All right, this is crucial. If the notes have been destroyed, I want a letter on letterhead stationery telling me why you destroyed the notes. Or if the notes don't exist, I want a letter on letterhead stationery telling me the notes don't exist. Now, I didn't come up with this on my own, all right? I heard this at a conference I was at in Chicago about 10, 15 years ago, but this is magic. All right. For years, I was asking for the contamination file in the DNA section. They were like, we don't have a contamination file. I send a letter with this language in it. I get a call. Oh, you mean the unexpected results file? We have that. You just didn't ask for it right. Okay, so for you guys, because if you don't know what your lab calls that file, it's DNA Advisory Board Standard 14.1.1 says labs are to keep track of unexpected results. I'm doing this on the fly. This is not a direct quote, but they're to keep track of unexpected results. When the scientist's DNA shows up in a crime scene sample, they need to document that. And it'll usually say something like, from now on I'll wear gloves. And I'm thinking, well, weren't you wearing gloves before? And then with some scientists, 3 months later, the same scientist is back in on another corrective action, right? From now on, I'll wear gloves. Same guy. Well, what happened in between there? All right, so there's valuable information you can get there. I also got the Drug Task Force manual using this language. I was told by the prosecution that the Drug Task Force didn't have a policy and procedure manual. Fine, I want the sheriff to put it. I happen to know our sheriff's department gets drug grant money. And I'm pretty sure the federal government isn't giving drug grant money to people who don't have policies and procedures in place, okay? So when I asked the sheriff to put something on letterhead saying he didn't have a policy and procedure manual, boom, showed up like magic. All right, you want the sketches that are created, and again, sketches are something that are specifically listed in NFPA best practices as something that should be done in an arson case. In any forensic science case, when you're getting stuff from the laboratory, you want their case notes. And case notes may be sketches like this, and you can see there's some language down here. Here's the front door. He's got point of origin right there. You get all sorts of information from those case notes. In DNA cases, you'll get little, depending on where you are, right? In DC, they take pictures, digital pictures of the evidence. In my lab, they draw little pictures of the shirt and a little blanket, and they'll circle the little areas where they found something was presumptively positive or lit up under the alternate light source. And so what do you learn from that? You learn, well, where exactly was the DNA found on the little girl's underwear, right? If you got 2 sperm found on a little girl's underwear, sort of on the waistband, and you know that sperm can transfer in the laundry because you read that study that came out of Canada in about 2001, as opposed to the sperm is found, you know, there's 15 per field and it's right in the little girl's crotch area of the panties, that laundry transfer thing is not going to work for you. All right? So you won't find in your final report how much sperm and where it was found, or how much blood and where it was found, or whether that, you know, the DNA is from a chunk of gray material that the scientist happens to think is brain. She doesn't put that part in her report. All right. Obviously, you want to get the CV of whoever it is that you're dealing with. So I had an arson case a couple years ago with Mr. Powers. He's got an AAS degree. I don't know what that is, so I looked it up. I don't remember what it is anymore. He took from the Minnesota Bureau of Criminal Apprehension, Arson Series, Basic, Advanced, Unseen. Is that 6 weeks each? Is it 6 hours each? All right? So we want to pick that sort of stuff apart. He's an executive fire officer. What the hell is that? All right? He's also not very good with detail because he lists the 2008 Minnesota chapter of International Association of Arson Investigators conference 24 hours twice. Okay? Did he mean 2008 and 2009? Or did he hit Control V twice by accident? I don't know. I wouldn't lead with that, but in the right case, if that's all you've got, you know, there's your CV. Okay.
Because a split second before the torque wrench was applied to the faucet handle, it had been calibrated by top members of the state and federal Department of Weights and Measures to be dead on balls accurate.
How accurate are the machines your labs are relying on? How often are they calibrating the pipettes? How often are they checking the machines to see that the results that they're running, are they running controls? Do they run a control once a day, right? A known sample of cocaine to make sure it comes out cocaine at the other end? Are they checking their scales? These things are documented in your crime lab, and if your discovery rules are right, and I got to tell you, I'm from Minnesota, and I'm not really pleased with our governor right now or our budget crisis, but I am pleased to tell you that in Minnesota I pretty much get whatever I want in discovery, basically just by asking a letter. So I appreciate that I'm spoiled in that regard, okay? Many of you don't have that. Maybe you have to subpoena it. Maybe you have to go to court for it. But put this on the list. How are their machines working? So we had a new crime lab open up in Minnesota and started doing DUI testing, and I don't remember if it was blood or urine, but they're doing DUI testing at the new lab, and after about 6 months the cops call them up and go, you know, your test results are always about a third higher than ours on the PBT. Now, the lab could have said, listen, you little cops, go back to your business, okay? The lab could have said, that's very interesting, but we are, after all, a crime lab, and you are, after all, cops, and so I'm sure we got it right. But instead, what the lab did, which they should have done, this was absolutely the right thing to do, they call in the Minnesota BCA, which is the other crime lab that we have, right, who helped set them up, and they had them do some test runs. And so one of the things they did, BCA brought out samples of alcohol, 100% alcohol, right, in grades, and we do these tests. And it turns out, at the BCA, they use one GCMS machine for all of their DWI stuff. And they have other machines that do other things. But at the new crime lab, they only have one machine. So while at the BCA, when they do their math, they've got that machine calibrated to take off a third, that wasn't going on at the crime lab out in Wright County. So they discovered it by doing a full investigation, then they reran, retested, and sent letters to the defense bar and the prosecution owning up to, whoops, our bad. Everything that they should have done when they recognized their instruments weren't calibrated. Many labs either don't know or don't have communication with the cops, or maybe they're testing something that they wouldn't have a clue whether or not it was calibrated or not. So you got to just take a look at that sort of thing. Also, if some machines, occasionally, there was the one machine that we used to call Old Sparky, that if you got we got the repair notes for it, because it was always going on the fret. So it was always that somebody was coming out to look at it and to tinker with it and try this and that. Okay, this was addressed before. You want to talk to the insurance company. They have more and better photos than your fire guy. They also have typically in my experience, longer reports. Don't forget the government, okay? So this fire inspection form was not in my criminal file. This is a document that I got at City Hall, and what I like about it is this part where it says sprinkler pipe being used as a coat hanger rack under steps in basement. Okay? So, interesting. Can I do anything with that? Actually, not in this case. But who knows what you're going to find, right? Another thing to be aware of in certain states, like in Minnesota, separate from the report that he writes for the cops, the fire marshal has to send in a report to the state of Minnesota, which somehow did not make it into my discovery packet. That's separate. Same is true in Minnesota for criminal vehicular operation. State Patrol has to send in a report that may or may not show up in your prosecution packet. And what I liked about this, my client was charged with burning down the VFW. This was right after the smoking ban went into effect in Minnesota. Well, not right after, because it was January, and it is cold in Minnesota in January, all right? And this bar had a little place where you could go off and smoke your cigarettes, but it was outside. And so there was this grainy video which maybe showed a couple of people maybe smoking a cigarette, maybe throwing it down the vent, and then the whole place burned down and there was $1 million damage. All right. And yes, they wanted that from my client. So I get this report and I'm just kind of flipping through it, and human factors contributing to ignition, none! I like that. I sent that to the prosecutor. Okay. So that's basically what you're looking for, is all sorts of documentation. Again, think outside the box, your videos, your standard reports that maybe are filed. CHIPS files, I just, in November, I tried a broken baby case, tried to get the CHIPS file. I got part of it, I didn't get all of it. I'm sure your appellate lawyers would say, ask the judge to put a sealed copy of the whole file into the file box so that they can look at it on appeal. But that can be a source of information. All right, now we're going to talk about some other. Well, it's fire specific, but really it applies to everything. So we've got suspicious fires, 75,000 chances to get it wrong. I think that's fair to say for most forensic sciences, right? Whether we're matching up shoe prints or fingerprints or whatever. So if we assume a 5% error rate, that's 3,000 missed calls a year, all right? And they could go either way, so sometimes it's, to our client's benefit. Some things I want you to be aware of when you are preparing for a direct or a cross of an arson expert. I got this from John Lentini, who, by the way, excellent, excellent book. Many chapters, if you don't have a chemistry background, you won't understand, but many chapters you will, okay? So he says fire investigation is just like a forensic autopsy, although if you've seen that Frontline show on forensic autopsies, I don't know if that's the gold standard anymore, but if you look at the education of a forensic pathologist and the education of a fire investigator, okay? Now, we're getting better. NFPA has a list of things that a fire investigator should have. Many still don't, however, okay? Also, you have to have a college degree in science. You have to go to medical school. There's NFPA, again, has best practices recommended, but there's nothing necessarily required. You have to do an internship. To be a fire investigator, basically you have to used to have been a firefighter, okay? And then there's post-training. There's 40-hour trainings, 80-hour trainings, 120-hour trainings. And as you saw on our fire person's resume, he listed he had 24 hours at one training but didn't give amount of hours for the other trainings. And then what kind of trainings are they? Are they the kind of trainings that we're doing right now, right? Mostly lecture format? Or are they the kind of training we were doing before, where we were talking as colleagues and discussing and sharing? Or is it the kind of training like you're going to do tomorrow, where you're actually doing mock trial and putting the skills? Do they burn down buildings and then go in and try and figure out the point of origin? These are the sorts of things that we need to be questioning. Again, and it's not just for the arson people, it's for anyone. Oh, and they go to seminars, sorry. Okay, certification, state medical board certifies the forensic pathologist, right? Your employer or maybe your association, the International Association of Arson Investigators, can certify you. What does it take to be certified as an arson investigator? Honestly, I don't know. Okay, but we're going to talk more about certification in just a little bit. All right, mythology, and this is where my presentation deviates from John Lentini's. John Lentini says there is no mythology with pathology. I say, yeah, there is. Okay, well, I'm a little sensitive to that right now. Mythology in arson: shiny alligatoring, crazed glass, depth of char. If you see any of these in an arson report, you need to pick up the phone. Lines of demarcation, sagged springs, narrow V patterns, melted metal, spalling. I put an asterisk next to spalling. I think we have in our case packet, there's some discussion of spalling. I don't know if it's identified as spalling, but basically it's burned concrete. Okay? If you see the word spalding in your report, this guy really, really needs a strong cross-examination, and you probably need to bring in your own expert. All right? Because again, of all the sciences, I think this is the biggest offender when it comes to passing down from generation to generation, right? And there's a long tradition of the old fire investigator teaching the new fire investigator. And so what you can absorb is limited to what he can tell you, right? And what you remember of what he told you is going to be less than what he actually told you. So we've got some things to address. All right, I want to talk about what not to do in any forensic science case. I'm going to show you a clip, and then we're going to have a quiz. So pay attention.
Find an expert to refute the testimony of the expert used by the prosecution. Right?
Let me tell you what we did. Rob Dunn and I, who tried this case with me, we went and bought carpet. We went and bought lighter fluid. We poured the lighter fluid on the carpet. We set it on fire. And when it finished burning, it looked just exactly like the carpet did in Todd Willingham's house.
But I mean,
okay, where to begin? What's the problem with that? Aside from the fact that a defense attorney is going on national television to assure people that he's guilty, okay, which I'm morally offended by, but what is the problem with Rob Dunn and I, we took a carpet and some lighter fluid? What's wrong with that? We don't have the same conditions. It sounds like they went out to the back 40, okay? And I'm going to show you flashover is an important concept in that particular case, and when you're on the back 40, there's no ceiling, okay? That's problem one. What's another problem? Yeah? May not be the same brand of carpet, may not be the same weave of carpet, may not burn the same rate. What else? Yeah. Lighter fluid. The lighter fluid. There's a presumption that lighter fluid was used.
What does he mean when he says it looks just like the other?
I was so shocked to see him on television telling Anderson Cooper that the guy was guilty of sin, and I had to take him out to process this, right? But that brings up another point: is that what does it look like if you burn carpet without lighter fluid? That's called control, right? We want to see if there's a difference. So it's good if you're trying to do experiments, you want to see if you can help a client. I would encourage you to contact a scientist, right, to do this for you. All right. So here is some history, and I think this is helpful. It was funny too, but it's also helpful for you in other types of forensic science if you look at the history of the discipline. So in 1977, the Department of Justice wanted this survey and assessment of arson to be done. All right, so this is the document that was published. Here's the findings. Even though we routinely rely on burn indicators to determine whether or not a crime has occurred, there is, 1977, little to no scientific evidence or scientific studies to support this. This is the finding of the Department of Justice. We need studies about these burn indicators, especially false positives. Imagine what would happen if the court ruled our burn indicators were inadmissible because they haven't been scientifically validated. Can you imagine such a world? I can't. All right. In 1980, the Fire Investigation Handbook was first released. All right. This is the early version of what is now the NFPA. Okay? Now, pop quiz here. I threw in an arson fire. How do I know it's an arson fire? Well, there are obviously 3 different points of origin. 1, 2, 3. You can't have a forest fire with 3 different points of origin accidentally. So we know it's arson, right? What's the flaw? Right. I said there were 3 points of origin because I work for the prosecutor's office. Look at that. There is a single source of origin back here, and it's just kind of licking through where it can. Okay? Right? So we go back to question everything. 3 points of origin. I guess that depends on how you look at the picture. All right. So they, in 1980, issued these new standards that were not well received. Remember when you took that horrible class in law school about the Federal Register and how people can comment on new laws and things? Well, here are some of the comments. 100 comments were submitted to NFPA protesting the technical committee's decision to recommend the use of the scientific method. Really, here's what the fire investigators had to say. Scientific research is important, but fire investigation is not an exact science. Okay. Fire science are not laboratories. Scientific can only be used when there's scientific testing. I love this one. Fire investigators should not be subjected to extraneous questions concerning the scientific method if they're truly conducting a quality fire investigation and have the proper conclusion about the origin and cause. What? If I know the answer, why are you questioning me? All right. Systematic is a clear definition of what we do. Scientific would imply exact science, which is impossible, and the scientific method is oftentimes confused. This is the feedback, right? 1980. 84, National Fire Protection Association issues a 16-minute video of a test fire. This changed things for some people. Nice illustration of flashover, which we're going to talk about. Nice illustration in the nonsense of the heat rises theory, right? That's crap. You see that? All right. So fire burns fuel sources. It can be wood, it can be carpet, it could be a body, right? I saw this excellent presentation on body fat as an accelerant. Here's how it works. Fire starts in a chair, right? We know that heat rises, fire goes up, the heat goes up, and we get this thin ceiling layer of smoke and heat, all right? It's called the thermal plume. Now, you would imagine a cigarette on fire in this chair, the heat goes up, it's going to be longer before we've got this extending over this ceiling than the ceiling in your hotel room, okay, which is one of the reasons why burning carpet outside is stupid. All right, so once it's spread across the ceiling, it starts to come down, right, mostly down in a uniform fashion. Here's an arson that I had. It didn't get very far, but it was starting to, you see that soot on the walls, the heat's coming down. Once it gets to about 1,000 degrees, it explodes, okay? All of the fuel packages ignite, and everything burns. All right. Then the fire consumes what we call the lining of the room, which includes the ceiling, the walls, and the floor. So a flashover fire, like the one we have in our case, where you remember it said in the facts that another 4 minutes later, everything was on fire. That's flashover. All right. Meanwhile, in 1984, someone writes an article, Are We Kidding Ourselves?, that says some of the old firemen's tales that need to be discontinued are spalling of concrete indicates that an accelerant was used, right? Read, as far as your case goes, that concrete can only burn when an accelerant is used. That's crap, and we've known it's been crap since 1984. Big rolling blisters on burned wood indicates a hot fire and probably accelerants. Crap. Black sooty smoke indicates petroleum products. That one sounds good, doesn't it? It makes perfect sense. All right? Crap. Accelerant will burn a big hole in the floor. All right. 85, NFPA comes out with 921 Guide to Fire and Explosion Investigators. Okay? There's a 2008 edition. I, too, would encourage you to get it. Many arson indicators. All right, this is from scientific evidence. You might have that in your public defender's office. Scientific evidence in criminal cases. A lot of the indicators are deficient for want of any... It's like everybody knows this, right? The whole world knows this stuff is crap, and yet it's going on. Okay, here is an example of arson. This is on a chenille bedspread. Take a look. You got your fire here, but you can tell an accelerant was used because you know how chenille is. It's textured, right? You pour the gasoline on it. Some of it's going to run down in these little rivulets. It's just going to be absorbed. So that's an obvious indication that an took a can of gasoline and just walked in and poured it on, right? Because the only thing that burned is right in here, and this is just fine. This one, obviously arson. How the hell are you going to get a fire in the middle of the floor with nothing touching it? I mean, really. And this one shows what we call pour patterns. When you pour gasoline onto a floor and it's lighted on fire, where the gasoline was is going to burn hotter and faster than where the gasoline wasn't. There's obvious use of accelerant. Which one of those statements is false? Actually, this one isn't. That is a true arson fire. But doesn't it make sense? I mean, you hear this stuff, well, you can't have something burning in the middle of the floor. Of course, that's evidence of gasoline right there. I don't need to run a test. So, we're going to use those to talk about the NAS report. Despite the paucity of research, I love that word, paucity. Some fire arson investigators continue to make determinations about whether or not a fire was set. However, according to testimony presented by the committee, many of the rules of thumb that are typically assumed to indicate an accelerant was used have been shown not to be. This is straight from Chapter 5, which you now have, okay? Much more research is needed. Again, we've been saying this since '77. Much more research is needed on the natural variability of burn patterns and damage characteristics and how they are affected by the presence of various accelerants. And understand how times have changed since 1970. Right? Our parents' furniture was made of wood and stuffed with wool or maybe hay, okay? Your furniture is polyurethane, chemical, and chemical. Much more chemicals in our, and that burn hotter and faster than they used to in the old days. We need to do some experiments. And they asked for, hey, why don't we do some experiments to put arson on a more solid footing? Good idea. All right, so what's our legal strategy in an arson case? Fire exam, this has never been generally accepted in the scientific community. We have 30 years of research documenting that what they do is crap.
The intention of justice is to see that the guilty people are proven guilty and that the innocent are free.
I always laugh when I hear that. You know a public defender didn't write that line, right? I don't know that that's the intention of justice, but what are we going to do? Are we going to have a Fry hearing on this or not? Well, if you want to have a Fry hearing, and from a Fry state, general acceptance in the scientific community, you've got 30 years of evidence showing it's not generally accepted, right? Who is the scientific community? If you read Fry, the scientific community is not the lie detection people, is it? It's the physiological and the psychological authorities who understand heart rate, blood pressure, sweating, things like that. So they, in Fry, used a very broad scientific community. Now, my experience in Fry hearings in forensic issues is that the forensic scientists want to be the relevant scientific community. We are the relevant scientific community. Okay. In arson, I'm okay with that because I can find plenty of arson guys that will come in and testify that these burn patterns and the V patterns and the, charred wood is crap. All right? But what about the NAS as a scientific community? We've got lawyers, we've got forensics people, we've got law professors, crime lab directors, medical examiners. If they're the relevant scientific community, they've spoken. And they've said this stuff isn't up to snuff. So for a prong 1 general acceptance, you should maybe make a run at it. Now, prong 2, were the methods and procedures applied correctly in this case? Based on my training and experience, having done prong 2, generally I say don't bother. And here's why. When it comes to was it done correctly in this case, every time I've argued it, the judge says, this goes to weight, not admissibility. Okay? That's problem 1 is I lose, all right? I don't like losing, all right? But the other problem is now the prosecution is on notice on, first of all, just how incredibly prepared I am, right? But if I've disclosed any errors, the scientist is on notice and they're going to have a better answer the next time, okay? And the prosecution might be a little bit more prepared because they know I've looked into this and that they've been educated by my prong 2 hearing. So if the judge is going to say it goes to weight, not admissibility, as a general rule, and of course there's always going to be a case that's going to be an exception, but as a general rule, I don't do it anymore. Okay? All right. What does it mean to be certified? When you said, I, Christine Funk, am certified to do NIC field testing, narcotic field test training. I took it, passed it, I'm certified. Let me tell you what it takes to be certified in NIC test. You watch a 40-minute PowerPoint. I can get you a copy of the disc if you need it. I got it in Discovery. You take a 20-question multiple choice test. And check this out. Okay, so here's the question. This is a 2-day fry hearing on this. When using the NIC system of narcotics identification excluding the correction setting, an officer can assume once he obtains a positive test result, he can positively conclude that the drug is what the test indicates it to be and no further testing is necessary. True or false? So, that is false, because NIC is a presumptive test. But I put true in there just because. Because why? Because I can see my score. And it tells you what questions you got wrong. And then you can change them as many times as you want. And once you finish your 20 questions, you send them $9.95 and boom, you too are certified to do NIC testing. Okay? So we need to be looking into this stuff. All right. We'll get to Monty Python in a minute. I thought there was another screen on it. So another thing we need to look into is what kind of test is this? Is this a presumptive test or a confirmatory test? Okay? Do y'all know what the difference is? Presumptive means, you know what, it could be that thing. Confirmatory means it is. So, North Carolina crime lab. Anyone from North Carolina here? Okay, your crime lab sucks, but I told you that the last time I saw you. Okay? So, they did a presumptive test, phenolphthalein test, which indicates the presence of human blood. It also will indicate the presence of rust. It will indicate, I don't know, I think Coca-Cola maybe gives it. There's other things that will give it a positive, including animal blood, right? Radishes, red potatoes. Okay, it's a presumptive test. If it doesn't go positive, we know it's not human blood. All right? If it goes positive, could be human blood, could be some other things. Then they did what's called the Takayama test, okay? Takayama is not used by very many people because it has carcinogens in it and it's kind of dangerous, and it's, frankly, my lab thinks it's a waste of time. It's a confirmatory test to confirm, is this really human-specific blood, or is it red radishes or a bunny's blood or whatever, right? So they would do this test, presumptive, positive, confirmatory, negative, and they would write up a report that was absolutely 100% true, and it said, chemical testing yielded indications of the presence of human blood. Period. And that's true. There was a chemical reaction which indicated, among other things, the presence of human blood. Did a confirmatory test that came back negative. All right? One of the other lawyers talked about this morning. This went on for 13 years because we weren't asking for the file, or didn't know what Takayama meant, or didn't understand that phenolphthalein was, presumptive and not confirmatory, and people went to prison on this stuff. All right, so one of the things I suggest is, well, let's talk about what would happen if you don't see their expert before trial.
What's he do? Nibble your bum? He's got huge, sharp. He can leap about. Look at the bones. Go on, boy, chop his head off. Right, silly little bidder. One red two coming right up. Look.
You don't want to feel like that in trial, right? You think you can handle it? It's just a little bunny. You got your questions lined up. I would encourage you to go and actually speak with them. If you meet with their expert, you might actually learn what it is they're going to say. So I had a different broken baby case in the spring, and I went and saw the medical examiner, and he says to me, and this baby was seriously broken, okay? I mean, shattered skull, brain died slowly over a week while he was in intensive care, and of course there was retinal bleeding, right? And Andy Baker says to me as I'm leaving, Christine, I've known him for a long time, Christine, the retinas bleed more when it's an intentional injury. And I'm like, fuck. I get out, I get my car, and I'm driving home, and I'm thinking, now what am I going to do? They bleed more when it's... And then I thought, wait a minute! How do the retinas know if I do it on purpose or accidentally? And I thought, and the next morning I called a friend of mine who's a medical examiner, and I'm like, Susan, Andy Baker says, is that possible? She says, no. She says, you're absolutely right. All right, so if it had happened at first in trial, I would have had that same initial reaction and thought about those brilliant questions the next day when Andy Baker was back in Minneapolis and I was still out at the casino in Redwood Falls, okay? So it can be very helpful to you to speak with them ahead of time. Here is what the fire examiner testified to in this particular arson case. How many fires have you investigated? This is on the witness stand, okay? A little trial prep would have been a good idea. Perhaps 1,000, 1,200, 1,500 fires. Of those fires, how many turned out to be arson in your opinion? With the exception of a few, almost all of them. Okay, now you're in court and you're going, dang, right? But if you were not in court, if you had talked to this guy 2 weeks before and you called, oh, I don't know, the Texas State Fire Marshal and got the stats, between 1980 and 2005, average percentage of fires being determined arson, 50%. So you could go into court with that document, right? Either he's really bad at judging arson, or he's puffing for the jury, okay? Questioning continues. How many, based on your experience, how many arson fires have involved injuries or death? Unfortunately, fires injure a lot of people, kill a lot of people. It's about 50%. Huh. Let's look at some stats, shall we? Let's call the United States Fire Administration. 95 2005 average death rate in arson or in fires. That's 0.23% people, not 23%. Average injury rate, 1.22%. I appreciate it's been a long day. Your brains are full. I'll do the math for you. Is that 50%? It's way not 50%. Okay? So, again, a little prep ahead of time. Consider hiring a chaperone. What does that mean? So you're doing a DNA case, you think things are going pretty well, and the guy says that the Hardy-Weinberg electropherogram is stochastically imbalanced, and the loci minus A proves the alleles. Who knows what that means? I totally made it up. I mean, all of those words are DNA words, but I mixed them together in a sentence in a way that is completely nonsensical. Okay? But if you don't know that, how can you compete with that? Stochastically imbalanced is one of my favorite phrases. It means nothing. Okay? So sometimes, when you're thinking about what kind of experts you're going to hire, maybe you want to hire someone to look at the file like we talked about this morning. Maybe you want to hire someone to sit in the front row. Because it was amazing to me when a former DEA agent showed up when the local crime lab person was about to testify. My conversation on the phone with her was very different than her testimony. Because she knew he was a DEA agent. I always make sure to introduce him. Oh, hey, I just want to let you know, this is my pathologist that I've got sitting in here helping me. Right? It does two things. First of all, you're not screwing up the translation when you're talking to your DEA guy at the end of the day. Right? He's hearing it directly, so you know he's getting it correct. And it also tends to keep other experts from overstating if they know that there's somebody in their field that's watching. All right.
That's quite an impressive CV, Tony.
Okay, check their resumes. I think is go without saying. You want to check your expert's resume. You want to check their expert's resume. So, Scott Farrell down in Miami lists me. There I am, DNA expert, Christine Funk. I did not ask them to put that in there. We were going to be on the show. My friend Angelia and I were down in Florida for something else, and she knows him, and he was looking for someone to come in and talk about DNA and the Innocence Project and, how cool it is. And so we went down and we talked on the show. I honestly came across this by accident. Just because I say I'm a DNA expert doesn't mean I'm a DNA expert, right? Take this guy. This guy once testified he had a PhD in astrophysics. And then another time didn't mention the PhD in astrophysics. And the lawyer who was reviewing the transcripts for appeal, I saw her give a talk on it, and she said, I thought it was kind of strange that if you had a PhD in astrophysics, wouldn't you bring that up every single time? So she started looking into his background, right? She had his CV, she called, she tracked down. No, he hadn't been in this PhD program. No, the master's degree people hadn't heard of him. His college hadn't heard of him. So she calls him and says, I don't understand, right? Did you go to college or not? He goes, of course I went to college. Here's my transcript right here. And you know it's a real transcript because he got like B, B, C, B, got a couple of straight C's. Well, it's his last year. Didn't we all get straight C's in last year in college? Right? And he got an A, he dropped a couple things. The lawyer took the transcript, went to the university, went down into the stacks, pulled the classes that were offered in these years, and discovered that these were not. He manufactured a college transcript. What's that? Unbelievable. There you go. I'm with you. Yeah. Yeah, he did kill himself. He didn't kill himself until after it became public that for 30 years he's been lying on the stand about his experience. But then he did kill himself. That is correct. And I don't take joy in anyone's suicide, but he testified for years, right, about all sorts of stuff based on his training and his experience. All right, so how do I know if this is a good person or a bad person? Well, the truth is you don't, okay? You can start with the American Academy of Forensic Sciences. You can see if they're a member. The next question is, are they an active member? Do they go to the meetings, right? There are 3 levels of membership: associate member, member, and fellow. And I am not above emailing the academy in the middle of a trial. When someone says they're a member of the academy, I want to make damn sure that they're an actual member and not an associate member. Because how you become an associate member is you write out a check for $135, you fill out a piece of paper, and you have 2 of your friends say, yeah, that's a good person. And you mail it into the academy, and boom, you're an associate member. If you want to be a full member, you need to participate. If you want to be a fellow, you need to participate more. That's a good starting point, right? But the chief medical examiner that I was referencing earlier hasn't been to an academy meeting in 20 years. Okay? He's a fellow, because once you get fellow status, you don't have to do anything else. So it's a good starting point. Also, when you're looking for an expert, if you talk to them on the phone and they're constantly interrupting you, or my personal favorite, the guy that I will never, ever hire, who said, any prosecutor who knows anything about this is going to ask this question. Well, okay, it's an open-ended question, so we'll start with they're not going to ask you that. But I don't hire experts to tell me how to practice law. Okay, not interested in that. If they're rude to you, they're going to be rude on the stand. If you can't understand them because they talk too fast or they talk above your head, they're going to do that on the stand. It's helpful if you go to a scientific meeting to meet people and see how they, present themselves. People who, I swear this is true to an extent. People who don't brush their hair at forensic science conferences don't brush their hair before they go to court either. Okay? Maybe you don't care about the brushed hair. Maybe your jury does. I don't know. Just something to keep in mind. Right? It's all theater, right? What we do? Okay. Oh, I meant to take that out. Sorry about the siren. Okay, so the Technical Working Group for Fire and Explosives has made some recommendations, and you can use this in your practice. They recommend a college education. They recommend proficiency testing, training. They have a reading list, exercises, and methods of evaluation. Now this is a twig, a technical working group. Some of the swigs and twigs are on the web and some of them aren't. There's really no uniformity, and some of them are run by FBI and some of them are run by NIJ, and there's a movement afoot to get them all under one umbrella. That has not happened yet. And as I'm thinking about it, just a quick plug, forensicscience.gov, it's a government-run site, I know, but it's got some, they're tracking what the Obama administration is doing. He's got some White House subcommittees that are working on different things. All right, you can get that information there. DNA.gov, if you want to go to the DNA for prosecution, you are welcome to do so. You have to log in. You have to give your email. I can assure you John Doe's name is already taken, okay? But make up somebody else's name if you want, and you can put in any old Hotmail account you want, and that will work, all right? And you can get in and see what they're telling the prosecutors are best practices. DNA for defense, which I worked on it, so I'm a little proud of it. I think it's a little more thorough than DNA for prosecution. I don't know if it's up yet, but it's going to be up shortly. It's broken into chapters, so if you're looking for a specific DNA issue, you can find that there. Here's another technical working group. This one's on arson, fire scene investigation. All right? That may have some helpful things for you. And it tells you that there are only 3 examination conclusions. Origin was X, origin was X and Y, origin undetermined. Okay? So there's some standards that are issued. Accidental, incendiary, undetermined. Those are the only 3 that are supposed to be used. All right. Christine Funk's thoughts on training and experience. I graduated in 1989 with a degree in social work from the College of St. Catherine in St. Paul, Minnesota. And I don't know if any of you remember what was going on in social work in the 80s, but I was trained that I could identify victims of sexual abuse based on their behavior, how they carried themselves, what tone of voice they used, how they sat. Because that's what they taught us in social work in the 80s. And so I was like, this is excellent training, right? And then I'm interviewing this woman. She's in her 50s, doing a little pretrial diversion program, right? Because I was always in the criminal justice system. And I'm looking at how she's sitting and how angry she is and her tone of voice. And I say to her, were you sexually abused by your father? And she said, yes. And now I had experience. Training and experience, right? And in social work in the 80s, it was better than that. Because some people would say no, but you know what we knew in social work in the 80s? You were repressing. You just don't remember the damage that we caused an entire generation of families. I got out after 2 years. But the 80s and the early 90s were a dangerous time for training and experience. I don't put a lot of credit in it. I also find scientists use it because it shuts you up, and we need to start questioning. So there was a murder case, not mine, a different medical examiner in Minnesota. We've got a dead 2-year-old and a prolapsed rectum in the 2-year-old, right? And the forensic pathologist says, based on his training and experience, a 13-year-old's penis can't do that kind of damage to a 2-year-old's rectum. Oh, the defense was devastated because that was their defense, was it wasn't dad, it was the 13-year-old who was jacking off all over the trailer all the time, apparently, right? Here's my question. Other than his own penis when he was 13, what kind of experience does he have with 13-year-old boys' penises? Right? What kind of studies have been done about the variability of a 13-year-old boy's penis, right? What about a 2-year-old's rectum? He deals with dead people. How many times does he come across a prolapsed rectum? It's never the cause of death, right? What kind of training does he have on injuries to 2-year-olds' rectums? What experience does he have with live 2-year-olds? None, unless he has one, right? We need to training and experience my ass. He doesn't have any training on this. He doesn't have any experience on this. We need to be questioning that. All right, legal strategy. This language sounds really good, and I have to be honest with you. I think it's from NFPA, but I don't remember. All right, you got to have sufficient expertise about an area which you're testifying. You're not supposed to have a bias or an interest. So in my motion to suppress the testimony of the fire investigator, and I do put it in quotes in my motion because I think it's funny. All right, you don't have to. These are the minimum job performance for NFPA. Now, I knew I was right about this because I went and I interviewed my fire investigator. Here are the post-secondary education requirements. This is NFPA 1033. You need to have secondary education in fire science, fire chemistry, thermodynamics, fire dynamics, explosion dynamics, computer fire modeling. Now, the guy that I went and talked to, he's doing some additional work in fire at the local community college. They don't offer computer fire modeling. He will never have computer fire modeling because it's not available in the state of Minnesota. I want to argue he's not qualified. All right? List goes on. Fire analysis, fire investigation methodology, fire investigation technology, hazardous materials, failure analysis, and analytical tools. There's a laundry list of things that are supposed to be in that college education that they're supposed to have. Legal strategy. Investigator failed to use the scientific method in his analytical process and/or for drawing conclusions. If you look at an arson report that says, I couldn't find anything that told me what caused the fire, so I know it was arson, that's not the scientific method. Okay? Additionally, and this is in NFPA, okay? Recognizing the need. They need to define a problem, collect data, analyze it, develop a hypothesis, and here's the part that I've never seen. Test the hypothesis. I mean, I'm aware of one particularly famous case wherein there was a fire in a house. The guy said he didn't do it. The prosecution said he did. Turns out the house next door was the same shape and was made by the same builder at the same time, and they were going to plow it down, and this defendant had money, so he hired some fire experts, and they burned it down to see if it could happen the way that would not be arson, and it turns out it could. All right, I think that's called the Peachtree Fire. Fairly famous. Testing the hypothesis. Most of the time, we don't see that. You don't test the hypothesis, you're not following the scientific method. Upon rendering an opinion, according to NFPA, they're supposed to apply a level of confidence to that opinion. That is not 100%, by the way. A level of confidence, a confidence interval, indicates a plus or minus. I don't see this in my arson cases. All right, proposed jury instruction. If your judge is going to let him testify, even though he doesn't mean the NFPA stuff, why not ask the standard of qualifications for professional fire investigators? You may take into consideration the fact that this individual doesn't meet the standard or was unable to say that he meets the standard. Why not ask for it? Because if you don't ask for it, you know you're not going to get it. Right? How about this one? Standard of care in fire investigation is set forth in NFPA 9.1. You may consider whether or not the expert in this case complied with the requirements when considering how much weight to give their testimony. Right? The judge already said in your pretrial motion goes to weight, not admissibility. Why don't we tell the jury that they can take this weight into consideration? How valuable is this? Witness says the defendant pushed his car away from the fire scene. Okay? And as I recall, complained about the dartboard as you walk through the wreckage. All right. A description of somebody's failure to display what an investigator considers to be an appropriate amount of emotional distress is an unfortunate common theme in wrongful prosecutions and convictions. Okay? So we're going to start with that. Now, I think those sentences are brilliant. I didn't write them. I'll tell you where you can find them because you can cite them to your judges. All right? You go to the New York Innocence Project's website, put in Willis and Willingham, W-I-L-L-I-S, and Willingham, W-I-L-L-I-N-G-H-A-M. There is an investigative document that was referenced in your materials. They looked into 2 arson cases in Texas and wrote a sort of a scathing review of how it was screwed up, right? They had like 6 fire experts on this panel, and they all agreed that both of those convictions were wrong. Mr. Willis was convicted in part because he wasn't coughing, okay? And he didn't seem particularly upset that these 2 girls were dead, these 2 women died in this fire. Mr. Willis had just met these women that night. He was on pain medication and drinking. I know you're not supposed to do that, but he was. Okay, we'll forgive him for that, right? Pain medication, drinking, just had back surgery. He wasn't upset enough. Now, Mr. Willingham, who lost his 3 children, they thought he was too upset. Natural suspect, he was just too upset. Okay? So this language is language referencing that and talking about how this is a common theme in wrongful prosecutions. It's not unlike what was said this morning about motive, right? The guy's a jerk. He doesn't pay his child support. I saw him spank his kid in the grocery store, right? All of a sudden, people are coming out of the woodwork putting this guy on trial for motive, okay? And here again, this is ridiculous. Generally, people who are in a state of shock, emotional displays are not predictable and should not be the basis for any conclusions. Again, that's from that Arson investigation report. Assessment of the state's witness of a proper amount of distress to be shown from a fire victim lacks any scientific validity, okay? No science involved, all right? So if they want to introduce this, do you want to do a Fry hearing? Do you want to do a motion in limine? Something to get this before the guy takes the stand to talk about how he didn't cry at all, or he was crying all the time, or whatever it is that they think is relevant about your client's reaction. You need to educate the judge. People don't behave the way you think they would behave, right? I said this to my non-lawyer friends throughout the entire Kathy Anthony trial. Well, why did you hide the baby in the woods if the baby drowned? I don't know. I've never had a 2-year-old drown, but I'm pretty certain I wouldn't be thinking straight right afterwards. Right? There is no right way to behave when you've just lost someone in an arson fire. So we want to address that. All right. Okay, here's some. I have 3 case law slides, and then I turn it over to Stacy, who does the rest of the case law. But, you know, you've got, okay, Marvin was talking about this earlier. The guns and bullet testimony's been coming in forever. All right, so you say to the court, State v. Bain, science moves forward. Hypotheses and methodologies once considered sacrosanct are modified or discarded, and the judicial system, which is search for the closest approximation of the truth, must accommodate this ever-changing scientific landscape. So we've got at least the New Jersey Superior Court recognizing that things change, cultures change. The NAS report changed a whole lot of stuff. Okay? Next quote. Consequently, courts in Fry jurisdictions have not shied away from considering whether a theory which had been accepted in the scientific and legal communities continues to meet the standard. Okay, I apologize, I did not update that site. That's from 2009. So when you look at, those of you who do post-conviction, right, you've got the Strickland, Minnesota, or is that a U.S.? I forget. Right? It's a U.S., okay. So you've got newly discovered scientific evidence. We just yesterday, the Minnesota Innocence Project flipped a case on the guy was sleeping with his 3-month-old and his 3-year-old, and he wakes up and the 3-month-old is dead, and the baby goes to the pathologist, and the pathologist finds a skull fracture, and so then they send him to a different forensic pathologist, and that one says, well, he was last with the dad, right? The dad killed the baby, okay? So he says, I didn't do it, I didn't do it. We have a documented fall at Walmart, seen by other people. Mom puts the baby, don't do this, people, puts the baby in the car seat and props it up on the Walmart car seat, boom, down onto the parking lot the week before. Okay? Now, in 2002, 2003, we didn't know as much about babies and situational breathing, right, of sleep situations as we know now. So now we know, don't sleep with your baby. Baby can sleep with you. You can never sleep with your baby. Okay? Because science has evolved. We used to just think this was SIDS. It's not SIDS most of the time. You got the fluffy teddy bear in the kid's crib, or the little down pillow, or whatever. That's why the baby stopped breathing, because there was something obstructing their mouth, unrelated to the skull fracture. Okay? But we didn't know that in 2000, 2001, 2002. So we bring that evidence before the court, and the guy, yay, gets a new trial. Hopefully the prosecutor will, you know, just move on. But at a minimum, he's getting a new trial because we've got new science. All of you who have NAS report cases, it's new science, right? The shoe pattern thing, if you take a look at Chapter 5, the shoe pattern, I love this study. They sent a bunch of shoes out to a bunch of different shoe pattern people, and they got a bunch of different answers. Okay? DNA gets a pass with the NAS report. I don't think it should get a pass because of the interpretation is where the problems come in. So, New Scientist out of England sent a DNA sample mixture to 17 scientists in the same crime lab, right? All the same protocols, all the same rules, because we're in the same crime lab. One of them said that the defendant was included. 12 of them said the defendant was excluded. And 4 of them couldn't make a decision one way or the other. The guy's on death row. Because the guy at trial testified that he was included. Okay? I have 12 other scientists looking at that exact same evidence saying he's excluded. And only one says he's included. So be aware when you get your DNA cases, you open up the NAS report, they're like, DNA, fine, okay? There are problems with interpretation, especially when you get messy mixtures. So don't accept that as truth either. All right, and frankly, and I think this was referenced earlier, our standards for mixtures have changed. Our standards for calculating stats have changed. All right, what's our last one here? Due process considerations require courts to intervene if scientific opinion shifts so dramatically that a previously accepted method are now considered unreliable. So those are your sort of your post-conviction cases. Yeah, Paul.
I don't know if you're aware, but I think our own Supreme Court basically said that last September. So I point that out. They seem to be tracking that.
We're sort of coming around in the Hull decision. The defense asked for a prong 1 Frye hearings on handwriting and on something else that was important, which escapes me.
Fingerprinting and handwriting.
Fingerprinting and handwriting, there we go. And the court said no. It went up to our Supremes, and our Supremes said you should have given him a prong 1 Frye hearing. But there was so much evidence against this guy that it was harmless error, right? So he's going to stay in prison. But there slowly we're getting the NAS report is showing up in our Minnesota case and some other cases as well. So we're getting there, educating the courts. All right, now I turn it over to Stephanie. Stacy, I'm sorry, it's been a long